So good afternoon, everyone joining us on this webinar. My name is John Woods. I'm a partner with Chartwell Law, primarily out of our Philadelphia office. Today, we're going to be talking about protecting your retail operations from insurance and legal claims in a post-COVID-19 marketplace. So some of the things we're going to talk about here today are whether or not your insurance covers you for different sorts of claims, issues with home delivery, alternative delivery models or methods, issues that are going to be causing employees or customers to make claims against you, as well as our thoughts on kind of what we're seeing now, what we're predicting might happen in the future, and how best to protect your retail operations. So I'm going to start. We have a very distinguished panel with us here today. And I'm actually going to introduce all of them. So our panel today, we have Rob Baker from Chartwell, Michelle Herr, Alexis Pfeiffer. I guess I probably should have started that. And we're going to start with Rob Baker and let Rob introduce himself and tell you a little bit about him and his background.
Good afternoon, everyone. My name is Rob Baker. I'm a partner at the Harrisburg office of Chartwell. My practice is focused on employment-related matters, workers' compensation, human resources consulting, litigation, OSHA risk management, and policy development. Looking forward to speaking with you all here today as we go through the presentation.
Thank you, Rob. And next up, we have Michelle Herr, who is the Senior Litigation and Claims Administrator for Risk Management and Legal at PetSmart. So Michelle, if you want to say hi to everyone.
Hey everyone, I am Michelle Herr from PetSmart. I manage the general liability claims and litigation cases. So anything customer, third party, pet incidents, anything related to that. Thank you for having me and excited to be a part of this panel.
Thank you, Michelle. And last but certainly not least, Alexis Pfeiffer from Sprouts.
Hi, good afternoon, everyone. I'm Alexis Pfeiffer from Sprouts Farmers Market. And in my day job, I oversee really all of Sprouts litigation, ranging from commercial cases to employment cases, and as well as our claims team, which is responsible for all of our work comp and general liability matters. And I have a background primarily as an employment attorney, as Rob does. So I also do a lot of our advice and counsel work on the employment side. Very happy to be here today. Thanks for having me and looking forward to our discussion.
Absolutely. So the first topic really that we had on the agenda was insurance and whether or not the insurances, the different policies out there are going to cover retailers for different claims. Now, the four of us had a discussion about the different types of policies that are particularly or could be in play here, but I think we're going to focus in and just touch briefly on commercial general liability policies, workers' compensation and employers' liability policies, as well as employment practices liability. So those of you watching, this is not a coverage webinar. That's an entirely different conversation from the coverage folks, but we did want to touch on it. One of the things, just to kind of spur in this conversation, in 2006, ISO promulgated a virus exclusion in the business interruption policies. Now, that really doesn't affect our claims here, but after that, some of the commercial general liability policies actually started to include virus exclusions in those policies. And there's a lot of talk that after this pandemic, those virus exclusions are going to now show up in a lot of the GCL policies. So I guess my question for the panel is, what have you been doing to be proactive about the insurance policies? What have you done retroactively looking back? And what should our viewers be thinking about as it comes or what with regard to insurance? So Alexis?
Well, I can jump in and just say, as we're getting into renewal season for some of our policies, we typically do get together with our insurers and have a meeting. Usually it's in person. This year we're meeting with everyone on Zoom, and the bulk of our presentation addresses our coronavirus response because we know that our insurance companies have questions about that. So we've been very prepared to be transparent and talk to them about what we're seeing in terms of, number of employees who've tested positive, what we're doing in terms of cleaning, what we've seen from customers. And, we've been fortunate in that regard. We really have not seen customers coming back to us claiming that they've contracted COVID because of our stores. So that, for us at least, has not materialized. But we've been very transparent about what we've been doing on COVID with our insurers, and hopefully that will insulate us from at least some of the increases and from the hard market that we understand is out there. It was out there before the pandemic, and this certainly isn't going to help. So that's what we're doing, at least in terms of getting ready to renew our policies and understanding that those policies might look a little different next year than they do this year.
Michelle?
Yeah, I can agree. We did research our EL coverage to determine if there are any potential exclusions or loopholes in the policy for the pandemic, as well, business interruption and virus. I think the biggest thing is just to be prepared for the carriers to know, did the business display its rules about masks? Be sure that we have all of our documents in place, that any rules that were enforced, the exposure, retaining any evidence that exists of the claimant's time on the premises. So just kind of being proactive on what we can have for both counsel and carriers or whoever's looking to be, interested in those items on what we have done.
So Rob, this one's for you. There was a lot of talk when the virus, the pandemic first started. We were going into March, everything was closing down. And a lot of the webinars, a lot of the talks were about when we reopen, or stores that do remain open, that customers are going to have COVID claims. They're going to claim that there's COVID claims. The other thing a lot of people talked about were, well, if an employee gets a COVID claim, contracts COVID from working, and they get sick, can they sue their employer beyond workers' comp? And I know a lot of jurisdictions, for instance, New Jersey has exceptions to the workers' comp bar. Do you have any comments or thoughts on those type of claims as it relates to the insurance coverage aspect?
Sure, I think you're right. When COVID first hit, late February, early March, there was this concern that there was going to be a flood of workers' compensation litigation because of exposures at work. As time has gone on, we are seeing some of those types of cases, but I don't know necessarily that it's been that flood of litigation that people were concerned about. With some exception, if you're working in healthcare or other essential function frontline focus, at least in Pennsylvania and other jurisdictions, that may be easier to prove a work-related claim, whereas perhaps in some retail settings or non-healthcare, establishing the link of exposure to work, I think, is a little more difficult. So one of the things that we're doing is, if there is a claim, there's a very thorough investigation, as Michelle had mentioned, to really determine the claimant's activity and travel outside of employment or of the workplace, to see to what extent are there other contacts, that they have a spouse or a significant other or family member that works in a health setting. Is there someone else at home that has already been tested, things along those lines. With respect to the exclusivity provisions, most states do have that exclusivity provision where the employee can only sue for a workers' compensation claim in the workers' compensation environment and not in civil court. Most states have exceptions to that. If there's something along the lines of gross negligence or the failure to provide, I think, a safe workplace consistent with the OSHA guidelines. I have seen a few cases in the news where, for example, there's a claim in Indiana or Illinois that the claimant, the plaintiff, is suing outside of the workers' compensation arena because of the employer's alleged gross negligence at the work site by not providing PPE, by not practicing social distancing, by not installing the plexiglass dividers, and things along those lines. So those cases are in the works, but I don't know that we've had, at least from my perspective, that flood of litigation for workers' compensation, particularly that I think many people were expecting or concerned about.
So before we move on really to our next topic here, I do want to tell the viewers, if you do have questions as we're talking about things, on your screen you should have a Q&A button. So feel free, we're monitoring it. If you want to ask any questions of any of the panelists, feel free to type your question there, and we'll address it as we go along, as well as provide some time at the end if you have some questions. Obviously, with the pandemic, everything shut down except for essential businesses. So grocery stores, pet stores, those type of places that are essential to everybody's lives. But a lot of things changed. So one of those things was how people shop, how people pick up things, how we're now getting products and produce. So Michelle, have in your experience, I guess over the last couple of months, has that affected your claims in any way? Has that caused any type of issues for you?
Yeah, so we did see an uptick in claims for buy online, pick up in store, mostly related to property damage due to improper loading and signs not being secured. It encouraged us to provide better guidance for loading, supplied stores with traffic vests, curbside cutoff times, installment of those permanent fixtures and signs. It was a piece of the business that was not very attractive to customers pre-COVID because our in-store experience was, bringing in a pet. So yeah, we did see a little bit of an uptick in that, but acclimated accordingly.
And I think Alexis, on your end, with the home delivery and that type of thing, I think that was pretty smooth sailing for you guys, or no?
It was. We also had to accelerate some things to make sure that we had, in particular, buy online, pick up in store available at all of our locations, and our e-commerce team did an amazing job getting all of our stores up and running in very short order. But we really, fortunately, at this point, haven't seen any impact or change to our claims because of it.
I guess this is the question for both of you, though. For those stores that have been closed down, so not the essential businesses, but clothing stores or other people that we might have on this reviewing, what is your suggestion to them as they're getting into now, all right, we're finally able to open at 25, 50, 100% of in store and starting to do the type of things that you've been doing for the last 6 months?
Yeah, I have to say, at the time we were open, through the whole pandemic, and we were responding to things in real time as they were changing, it felt really difficult. I think it's probably a lot harder to have been closed and to have to implement everything all at once. So I think it's very important to be extremely familiar with whatever the current public health department guidelines are in the cities, states, counties where you're operating. And different states will do things differently in terms of the power that a county department has over a city and those kinds of things. So you need to figure out those kinds of issues. Along those lines, it can be very critical to know where your stores are located. So taking California as an example, a lot of the counties that have passed supplemental COVID sick leave requirements, those requirements only apply to unincorporated areas of the county. So you need to know, is my store located in an unincorporated area of the county, and therefore this rule applies to me? Or am I in, for example, the city of Sacramento? So the Sacramento County ordinance does not apply within city limits. So there are a lot of ins and outs. I've found it very helpful just to have a chart with the county of every single store, which is not something we had readily available. We made one, now we have one. Because we've had times where we're sitting with maps going, all right, which county is this store in, because it mattered for requirements. So you've got to get really familiar with those requirements. And then I think there's a philosophical decision that has to be made as to whether or not you want to manage to each individual location, or whether you want to look at perhaps the most restrictive set of rules and apply it to all of your locations if you have multiple locations. And, it's a big decision. It's definitely easier to manage that way. But there are certainly states and counties and cities that have stricter requirements than others. So you can find yourself kind of butting up against, a local norm if you go into a place with stricter requirements. So there's a lot of conversation to be had around that as well. But even just in terms of things like making sure you have all the required signage posted, if you're in a place that requires a social distancing protocol, are you on the right form, and do you have it posted and registered with the county if you have to? What are your rules going to be for your team members? Are you going to put any special policies in place? Are you covered by federal FFCRA or state or local leave rules? And if not, are you going to apply some kind of internal policy similar to those rules? So there are a lot of decisions to be made, I think, for those businesses that are reopening.
Michelle, did you have something to add to that?
Yeah, I'll add, any possible way to eliminate the spread or contamination. So in addition to the requirements Alexa mentioned, it is that making that enterprise decision to stay in line with other businesses, the one-way aisle signs, the acrylic shields, the face coverings. In the case of a claim alleging exposure to COVID due to contamination of the business premises, you want to confirm that if that person was infected, was known to be present, determine what protocols were in place to safeguard the customers, those third parties and employees as well. But yeah, it's just, such as cleaning and documenting or decontaminating the premises, and what PPE was provided to the associates.
One of the things that I want to talk about, and it's something that the four of us have talked a lot about, is not just the physical impact of this pandemic, but on the toll that it takes mentally. So not just getting the disease, but being shut down, having to deal with children, having to deal with all of that. And I'm going to pull up a couple slides here just to share a little bit. Somebody else should have done the technology, but so mental health and psych claims, and it's not just even the claims, but it's how you deal with your employees in general. So one of the things, so the U.S. Center for Disease Control, CDC, said 40% of Americans surveyed say they now struggle with at least one adverse mental condition during the pandemic. So depression, anxiety are the most common, obviously. They've also said that, so younger adults, minorities, and important for us, essential workers have been most affected by the mental aspect of this disease. Again, they say that, you can see the numbers here of just how much of an increase from even last year, mental disease has become an issue. Suicidal ideation. So obviously this is taking a dramatic effect on Americans in general, but especially the essential workers, the people that are on the front lines in the stores dealing with customers. So I guess the first question is, as a retailer, how are you addressing, or how do you address that mental health or psychological harm that's being done to your employees?
Well, I think, I guess, John, one of the things that we were all talking about as we were preparing for this is that COVID fatigue is a real thing. And I think, probably everyone feels it to some extent. Some folks are tired of wearing a face covering for 8 hours a day. Some folks are tired of being asked to wear a face covering when they enter a store. And I think what happens the longer this wears on is you see that people are a little bit raw. And, they're bringing their whole self with them to go grocery shopping. And one of the things that we've really tried to focus on with our team members is how to de-escalate some of the tension that comes up with customers is when we're trying to enforce our COVID regulations. Workplace violence, unfortunately, always is a concern. But I think it's been a heightened concern as the pandemic wears on. And, we're not even going through the pandemic in a vacuum. We have a time of civil unrest. We have a contentious election coming up. So making sure that the team is armed with resources, first of all, to deal with some of the customer energy that's coming into the stores, which unfortunately isn't always positive, and really reminding them, of our de-escalation steps. and taking them through that. We've had de-escalation training in place for a while, and we've overhauled that to really address some of what we're seeing today. We also try to make things fun still where we can, which is a challenge. We're continuing to have our team member appreciation weeks, even though they look different, because maybe not surprisingly for a grocery store, sharing food was a big part of that. That's not really something we can do right now. But even things like allowing some customization of face coverings, still managing to have team member appreciation events, featuring team member stories in our newsletters, those kinds of things that continue to build team spirit, including certain hashtags on Instagram and those kinds of things to continue to make things fun for people, I think is helpful. And then we've really focused through our HR team on getting wellness resources out to our team members, things that we already had in place, generally speaking, through our benefits program or employee assistance program. Different wellness topics are now featured in our online newsletters and in our intranet to really just make sure team members are aware of what we have available to them if they do need help. And then when folks are having, some kind of mental health issue, of course, we work them through our accommodation process as we would any other time. But it is important, just because we're dealing with a pandemic doesn't mean we can set aside our obligations under the Americans with Disabilities Act or the relevant state laws. We still need to sit down with our team members and say, how can we help you? It seems like you're going through a tough time. And if there's something we can do to accommodate, as there is in most cases, then we will do that. But it's a matter of keeping up that good practice, even though maybe the situation is a little bit different.
And Michelle, I know you rehauled some of the policies and procedures on this issue with your associates, right?
Yes, we do. We acted by messaging through our code of ethics, which provided associates on, how to react and respond to customer behaviors, the new complex challenges with coworkers and our no tolerance for retaliation, mental health awareness offerings and encouragement to use your voice, anti-discrimination best practices and focus groups. So yeah, we did put a lot of emphasis into it and applications out there. But like Alexis said, yeah, COVID fatigue is a real thing. So I think it's preparing your field leaders, your stores, any employees and associates to increase that awareness and continue to prepare them for potential increases in civil unrest, escalated interactions with customers. I mean, we're getting, an associate is preparing or, trying to educate a customer on a product and it quickly turns into an allegation of discrimination or assault. And that's something that unfortunately they're just not familiar with. So it's definitely those levers that we're putting in place and just kind of an action plan and de-escalation for safety.
Yeah, and we're going to talk about some of the specific types of claims we're seeing as a result of this in a minute. But I wanted to turn to Rob for a second and talk about, again, so many retailers have reopened. Some are now just starting to reopen and going through that process. So there's this entire conversation now about return to work, right? Bringing everybody back into the offices, bringing them back into the stores. And there's some real issues or potential issues with discrimination claims, employment claims, ADA claims, and the like. So I want to first talk about a type of discrimination claim. So according to the EEOC, women, and particularly women of color, are more likely to be primary caregivers. So as a retailer, are retailers allowed to give consideration, or should they give consideration to, race, color, sex, or situation in deciding who's coming back to work?
Well, I think at the outset, there's a few things. One, I tell clients to be flexible with staff. It's a stressful time right now for everybody, especially if your children are at home learning virtually, or if you're a single parent, or if you have elderly parents that you're caring for. Those are stressors notwithstanding COVID. So I think flexibility in dealing with employee requests is very important. I also think that applying the policy for return to work whether it's by all staff or certain demographics within the staff, example, cashiers or stockers or something along those lines, is also important. The consistency, I think, eliminates or reduces that likelihood or potential that there's some discriminatory action, even if it was unintentional. The consistency of policy application helps with that. The one thing that is maybe a recommendation is to look at the adverse impact and run that analysis of how are your policies that are being applied affecting the groups that are returning to work, meaning the highest group that's being affected, and then the statistically thereafter, to see if there is in fact that statistical correlation that if minorities are being adversely impacted by the policy and its application. So there is that potential, but I think that if you follow your policies consistently, that it does greatly minimize that possibility.
Everyone talks about this pandemic and having more vulnerable types of groups, right? So the elderly or the pregnant or people with diabetes or people that are obese. So it's very easy for, I think, someone to go, all right, well, I want to bring my employees back, but I don't want to put the older employees in extra harm because they're an at-risk group, or I don't want to bring this employee back because they're in an at-risk group. So Alexis, what kind of concerns do you have about employers, retailers, managers saying, out of concern for my employees, I don't want to bring back certain classes of employee?
Yeah, well, I think you're potentially setting yourself up for a discrimination claim if you take a class-based approach. To me, that feels very dangerous. So you're always better off having an individualized conversation with employees, even though it might take a little bit more time. We really should not be making assumptions about people just because of their age, or even because, they're pregnant, or even because of a known disability. And we certainly shouldn't be assuming that somebody already is disabled. So that's going to be a claim in and of itself. So you want to make sure you're having conversations with people. And if there are a couple of folks you're worried about, call them up and ask them, are you comfortable coming back to work? And, if not, how can we help you? How can we help you is my favorite ADA question, because it doesn't assume anything. It's very open-ended, and it lets the employee take that question in whatever direction they need to feel comfortable and feel heard. So those are my thoughts. I will say that at least at the beginning of the pandemic, and we're not in every state, we're in, I think, 23 states. I believe it was Delaware that did require us to hold out people over a certain age in the very early stages of the pandemic. And so we had folks out, and, as Rob tends to advise, we've been very generous in terms of time off and accommodation with people, because really I don't see how you could not, in this situation. It's just beyond, I think, what anyone has dealt with before. But we did have that situation for some of our team members in Delaware, where folks in certain groups were required to be out under public health codes, and not all of them were happy about that. And most of them came back almost right away, as soon as we were allowed to let them come back under the health code. So I don't believe there's anything currently in place like that, although we are starting to see some places put certain restrictions back in. I would be somewhat surprised to see anything that severe, but it doesn't mean it won't happen.
So both of you and Rob touched on this a little bit, but what is the impact of the ADA on, these type of COVID related issues? So, I mean, is COVID a disability under the ADA? And how does that play into bringing people back to work?
So are you ready for my obnoxious lawyer answer? It depends. It depends. I mean, generally speaking, short-term conditions like cold or flu, even allergies that are mild enough, those are not going to be disabilities under the ADA. But we also know the ADA was expanded, 10, 12 years ago to include function of any kind of body system as a major life activity. And so I think that makes the analysis as to whether COVID is a disability or not very interesting, because we also know that there are people who may not even get super sick to begin with, but they wind up with some kind of neurological impact, or they wind up with a heart condition, or they wind up with some impact on their kidneys or another major system. In those cases, those people probably have a disability. But I think, again, if there's any doubt, put the person through your ADA interactive process, because I think, generally speaking, when I was, a baby lawyer 18, 20 years ago, it was possible to win cases on the grounds that somebody was not disabled within the meaning of the ADA. That is extremely difficult to do now, and I think it's not a good plan to hang your hat on that, especially in a time when we really do need to work with people. So again, you don't want to assume that COVID is a disability, but you're going to have to talk to the employee and figure out what their particular situation is. Probably if they have some kind of disability because of it, it's not going to be something that's obvious and visible. So in that case, you're entitled to ask for medical information, and you can and should follow your standard ADA process to do that. But I think what you really need to do is follow the ADA, work through that individualized inquiry process. The ADA now has a list of conditions that are assumed to be disabilities, and it's things like, common types of mental illness, epilepsy, cancer, various other common conditions that I think it's hard to argue are not disabilities, and any condition not on that list has to be considered on an individualized basis. So that's where COVID would fall. Again, the more impact on a major bodily system, the more likely I think it is that it's a disability, but you're not going to lose anything from a legal perspective by walking that person through the interactive process, and just keep your documentation along the way to show what you did and when and how you worked with the employee. What I like to tell folks on the ADA is, generally speaking, we don't want to be the ones who say no. We want to make sure we keep that conversation going as long as we possibly can. And it doesn't mean that we always reach a resolution, but boy, most of the time we can get there. But it's a matter of good communication and making sure that those questions get to the right place too. For us, we have a centralized team that handles these kinds of concerns. So making sure that our stores know if you have an employee who has a concern about an accommodation, get them to this particular team and we'll work through it with them.
So one of the things that we've talked about is, having all of these additional procedures. So disinfecting everything, making sure that, before we're starting work, everything's washed, decontaminated, making sure that the employee himself is decontaminated or she is decontaminated before and after. So Rob, this is really for you. Are there wage and hour concerns about requiring employees to have extra type of washing or decontamination before they start their shift, and then after they end their shift? Are we required now to pay employees for pre-shift decontamination?
I just want to add one thing to Alexis' comment with respect to the ADA. I think the reasonable accommodations that you'd be looking at in issues related to COVID are things that we're already doing, right? Like masking and walking one way in aisles and the barriers and things. So it's really just good practice to engage, as Alexis said, in that interactive process, that dialogue of asking the employee how we can help them, because one, it's for everyone's safety, and even if COVID is not covered by the ADA, as Alexis said, chances are that someone's either susceptible. If they're susceptible, they may have an underlying condition that would be protected by the ADA, or develop something as a result of COVID. So it's really just an ounce of prevention, I think, that goes a long way, because most of the accommodations that people would be requesting are things that we're already should be or are engaged in for everyone's safety. So with respect to the extra time before and after one's shift, I would submit that would be additional time that would be compensable as part of the of the normal shift. If you're having them come in early to prepare, that could be compensable. Certainly, would they clock in and then would begin that preparation, and at the end of the day, decontaminate and clock out. That, in my opinion, would be the safest way to avoid any wage and hour complaints that employees may raise.
And Alexis, Michelle, have you seen any of those type of claims or complaints?
Thankfully, no. I was extremely worried about that at the beginning, and so we've been very careful that anything extra we're asking employees to do, they're clocking in first. Also, and somewhat surprisingly, there was some pretty helpful guidance from the California Department of Industrial Relations on temp taking, especially at-home temperature taking in California, which I thought might be a hot area, but they came out with some guidance that was actually pretty employee-friendly and walks through very carefully when temperature taking at home versus having it be done at the store is compensable versus not. I refer that to anybody who wants to take a look. It's probably pretty easy to find if you Google it, but it's nice to have some Q&As out there on those kinds of practices, especially in California, where you've got the risk of Private Attorney General's Act claims and other claims, as well as your standard class action.
So talking about bringing employees back to work again, so kind of backtracking, again, a lot of your employees just continued on working through this pandemic. A lot of employers are now just trying to get their employees back. So we have a lot of these return to work issues, but, and I guess this is really for Rob and Alexis and Michelle. We're going to talk about the GL stuff, you and I, in a minute. But what if you have an employee who's not sick, doesn't have a family member who's sick, but just says, you know what, I just don't feel comfortable coming back to work. What are your recourses?
I'd be interested in hearing Alexis first, because I have some that are doing other things. So I'd like to hear Alexis's comments first.
Yeah, I mean, we haven't necessarily had our folks, get the chance to get involved in other ventures, but I have heard those stories from colleagues as well. People who have taken up a second job when they've not been able to work, and that's maybe now taking over the first job. I think that's a particular challenge. But again, you'll get the sense I'm really into talking to our employees. So, I'm going to come back to have a conversation with them and really figure out why. One of the things that you have to check is, even though that person might not be sick, might not have an at-risk family member they're considering, might not have childcare issues, those are kind of the big three. Maybe they do have some concerns that you're not doing enough for safety. And so it's really important to flush out whether or not that is the issue, so that you can talk to them about all the great things you are doing for their safety and walk them through your programs, walk them through the resources and the support you have available for them, walk them through sanitation, whatever it is that they need to feel a little bit more comfortable about returning. In some cases, that might be helpful. And in some cases, it may not be. And then I think, you run into having those more difficult conversations with employees, where you find yourself in the situation of saying, okay, well, if you're not going to come back, then we're going to consider that you're resigning or something along these lines. But I think most of the time what we find when we have these conversations, and in our context is generally with folks who've been on leave for one reason or another, is that there really is still some underlying concern they have on a personal level that's keeping them from coming back, or that there's just something else they needed to know about our response before they feel comfortable returning. But I think, again, worth your time to have that conversation. And then you've got to do what Rob said before, you need to be consistent. So if you start off down a path where you're having conversations with people and you're trying to figure out why they're not coming back, and you're saying, okay, in this situation, we'll give them a little bit more time. In this situation, we're going to go ahead and put them on the schedule. Then you need to be consistent so that you don't open yourself up to discrimination claims going forward.
Yeah, I agree. I have seen some employers take a harder approach after having that discussion. I think the discussion is also important, because if you're not aware of something as the employer of why that employee isn't returning, and then they are just simply terminated, in my mind, I would have some concern of a claim of retaliation, even if you weren't aware of some situation that the employee wasn't comfortable in returning. And if you have that dialogue, I think that helps limit that likelihood. So I've seen employers where they have that discussion, and because of business necessity, they will consider the employee to have voluntarily resigned and fill the position. In some cases, I think too that if the employer is able to absorb the absence, another approach that I've seen is where people are permitted to stay on an extended leave for some period of time if the situation's warranted. Not necessarily every situation. I think secondarily related to all this has been the unemployment compensation system. The state benefits vary state by state, so the state benefit could be very high or very low, but with the federal subsidy originally up at $600 and is it $400 now? Many people might be more comfortable, depending on how much they were earning at work, to simply stay at home and not have that fear of exposure. That has an eligibility issue for another seminar, maybe for unemployment, but I see a lot of that too, where people are they are able to stay home because of the unemployment program and the federal subsidy, the federal UC benefit, and they just have no desire to return to work even if the job is available.
So Rob, I don't want to spend time on this because I know you do an entire separate webinar and you lectured on this. But what benefits? I mean, we've talked about the unemployment benefits, but what are the major benefits that are now available to the employees? And I'm sorry, and should as an employer, should you be telling your employees who don't want to come back to work about what's available for them?
So the primary benefit is called the FFCRA, or the Family First Coronavirus Response Act. I'll say that I'm guessing that our panelists have more than 500 employees, so it doesn't apply to them. The act provides paid sick time and extended FMLA benefits outside of the normal FMLA program. So certain employees of employers that have less than 500 employees. The interesting thing is on what I call the EFMLA provision, if you're employed for at least 30 days prior to the injury or to the request for COVID, and there's 5 factors of eligibility. Even if the company doesn't otherwise qualify for FMLA, they're covered under the EFMLA provision. The same with e-sick. E-sick actually applies to all employees on the payroll as of April 1, 2020. These benefits go through the end of the year as of right now. There's a sliding scale of benefit eligibility with caps. Not to get too thick into the weeds, the employer can take credits though for the payroll because of their payroll continuation benefits. So on the back end, the employer gets tax credits for the payroll and the health benefits that are paid pursuant to the FFCRA. To answer your question about notice, absolutely. The act requires posting of actually I have it, the employees' rights poster for all employees to receive and view. The one question that came up right away is everybody's working from home. How are they going to view the poster? So our advice and the way our firm did it, we emailed it to every employee so they received notice under the act. So that I don't know how much you want me to get into the eligibility, John, because that's kind of not what we're discussing, but there's eligibility for folks who are quarantined if they by state, federal, local, if the doctors told them to quarantine, if they have kids that can't attend school because their school is closed. That has a separate issue though. If we have time, we can talk about it for people that are electing not to return to work because they have children and they're electing not to send their children to daycare or to school. I would argue that the employee is not eligible for this benefit in the second scenario where they're simply electing not to return to work, but they have their own self-induced childcare issue.
Okay. So and again, I appreciate that. I know that topic is an entire separate seminar that we don't quite have time to get into. So one of the other things that I did want to talk about, and really getting back to kind of Michelle's wheelhouse here, is the general liability claims that are arising out of the pandemic. So again, when this all came out, everyone I think was concerned. There was a lot of writing, there was a lot of webinars on COVID-related claims, i.e. somebody's going to come into my store, they're going to contract COVID, and they're going to sue us because they got COVID. I don't think that we've seen that, floodgate of litigation that people were talking about, and certainly you can correct me if I'm wrong. And I think there's a lot of reasons for that. I think one is a lot of states, I think we're up now to 25 states that have enacted liability protection measures, mostly for hospitals, but also for essential businesses, and a lot of other reasons. But I guess I'll ask the first question. I mean, have you seen any of those type of claims?
Fortunately, no, we have not. Luckily, those floodgates haven't opened up, but it did scare us. So in an effort to prepare, we, other than our standard interview questions that we ask a claimant, we've, implemented some, has the claimant actually been diagnosed by COVID? What did the claimant first exhibit symptoms? What claimant tested? Where they tested? So just kind of geared a little bit more on the investigation piece and interviewing the claimant on that and being prepared to ask those questions other than, the standard general liability interview questions. We have seen a few related to face covering. So a woman came into our store and fell, claiming that her glasses fogged up because of the face covering. So we are seeing that a little bit, kind of navigating responses to that, as well as the hand sanitizers, skin irritation, slip and falls due to possibly it leaking on the floor, making sure that you have a designated place for that hand sanitizer so that it doesn't leak onto a potentially slippery surface. So again, yeah, some new things that we've seen out of the norm, but definitely the best thing that I think we're doing is just being prepared for those investigations and also connecting with the claimant on the back end in the event, any discovery comes forward.
So going back kind of, the pandemic fatigue, and I think, Alexis, you said, people when they come into stores now, they're bringing themselves and they're kind of raw, and you have a lot of issues. I know recently you had a pretty bad issue between a customer and an associate, likely as the result of some anger on the customer's part. So what type of claims or what types of issues are you seeing as a result of this, mental fatigue?
Yeah, I mean, I think unfortunately for some people, the pandemic has brought out the best, and for others, not so much. We've had a couple of situations where customers have actually gotten into altercations with one another outside of the store, generally face covering related. And unfortunately, we have had some employee injuries because customers are unhappy with some of the policies that our team members are attempting to enforce. And I think it's an ongoing concern for us because, we're trying to comply with public health orders. We're trying to comply with our policies that we've adopted because we believe that they help keep our customers and our employees safe. But, unfortunately, not everybody agrees with that. And it's become a very divisive issue. And that does come into the store. So, we've been lucky in that no one has been killed. That has happened at other retailers, unfortunately. And I think it's a heartbreaking situation for them and really a tough situation for these workers who are on the front lines in a way that many of us haven't had to be during the pandemic and now have to deal with this additional stress as well.
Michelle, and same question to you. I mean, what type of things, not just, physical violence, but what other types of claims are you seeing that are kind of the result of this, just everybody being on edge and angry all the time?
Yeah, definitely. We're seeing the discrimination claims. We're seeing the allegations of assault, whether it be physical or verbal. So again, our associates are put into situations where it's very uncomfortable. A lot of them are very young, and it's scary. It's nerve-wracking for them. They don't know how to respond. Potentially get law enforcement involved. They may get a citation from them. So it's a different breed, and it's certainly just, again, trying to provide them with those thresholds for action, how they can respond, that de-escalation, and then, looking to leadership on whether it's something more extreme like the temporary closures or protective orders, whatever we have to put in place in the event that there is anything harming against the associates or the premises. We did experience some civil unrest related events, caused some closures and board ups, including a small number of stores experiencing the property damage of the looting. Thankfully, again, associates weren't injured related to the events, but just completely different than, their everyday going to the store and do their task performed.
Yeah, and I know we're running a little bit short on time, and I anticipate at least that we're going to see, and we may not have seen it yet, but the claims for negligent security, the claims for assault, the claims for wrongful imprisonment. I see those claims coming down the pike. Have you seen any of those filed or made yet? Fingers crossed.
I feel like I've seen some on some of the litigation databases. I do think I've seen that involving a security guard, and it was at a retail establishment. I've only seen a handful, and we have not had any ourselves. But it does sort of underscore the importance of making sure that if you are going with private security, you know what you're hiring and they understand what your expectations are.
Michelle?
Yeah, I can agree. It's definitely look into whether it's security or any other vendors that you have on site for that additional protection, making sure that the protocols are in line with your protocols, and you're all on the same page to obviously protect the associates and customers and pets for that matter.
And so that really leads me to the next topic, and I think our final topic that we're going to have time for is, the pandemic shut down a lot of stores, but it didn't shut down the essential retailers, which means it also did not shut down the operations that support our stores, right? So all of our vendors. So we just talked about vendors as security guards, but that also includes truck drivers and merchants, whether they're in the stores creating displays. What type of things are you seeing with the merchants who are coming into the store as it relates to either COVID compliance, issues with the health department, or claims that are potential claims that you're seeing?
So I can jump in. Just for us, we do have some in-store vendors. For example, our sushi that's prepared fresh in store is prepared by a third party. And one of the things we've found, particularly in California, is that the county inspectors want to make sure that vendors that are in store like that have also executed the required social distancing protocols and other postings. So it's worth making sure your vendors are aware of that expectation. And, again, being a little bit careful with the lines there on who's completing the forms. But, I think just some partnership and communication goes a long way in that regard. Also, we have our vendors go through the same kind of symptom check and self-check that our employees go through before they come into the store. That is still required by a number of public health orders. And so we've just instituted that around. And you have to be careful with even simple things like sharing pins at a receiving dock and those kinds of things. So it's a matter of being consistent with your policies. Our vendors are also required to wear face coverings in our store. And then we do make sure that we share vendor COVID positive tests with our teams. And we do our same contact tracing process when we're notified of a vendor positive that we would when we're notified of an employee positive, to see if we have anybody who needs to be quarantined, and to make sure that we're keeping our teams informed and protected.
And Michelle?
I'll add, it's, making sure that vendor agreements are, looked at as well. So we look closely at the agreements to ensure that there was strong indemnification language specifically related to COVID, making sure that the liability coverage was on and off the premises if you're using a home delivery company, whoever your vendor is of choice. Just making sure that those languages are tuned a little bit tighter as it relates to COVID. And again, just making sure that they're in line with our protocols, whether it's the screenings, whether it's the face coverings, inside our store, all of those policies that we have in place, you want to keep in line with those vendors.
Yeah, and I was going to mention that, and it's really not really a discussion, but just a mention for those listening. I think for retailers or for any company right now, it's a time to take a close look at your contracts with your partners, with your vendors, and making sure that that indemnification language is specific, so that you don't have general words of import that you're going to indemnify me from any claim. Most courts around the country, each state's different, but most courts are going to say that's not sufficient. So making sure that you're having your lawyers, both in-house and house counsel, taking a look at that and making sure that you have specific language in there that the vendor is going to indemnify you as the retailer for your own negligence. So if there's allegations that the vendor was negligent and you, the retailer, were negligent, make sure that your language is specific, that they're going to indemnify you for allegations of your own negligence. And with the vendors, I think it's even more important to make sure that that language is they're going to indemnify you even from claims of injury to the vendor's employees. Because inevitably what will happen is you have a vendor in the store, they're going to get hurt, they collect workers' compensation from their employee, or I'm sorry, their employer or the vendor, and they turn around now and sue you as the retailer. Well, if you don't have specific indemnification language in your contract, that vendor is going to indemnify you for injuries to its employees on your premises, you may be stuck now paying a claim to one of your vendor's employees. So I think now is the time to really make a concerted effort, take a look at those contracts, specifically the indemnification language in those. I think we have run out of time, which went quick. We have a little bit more time, I think, for questions and answers, but I wanted to give both Alexis and Michelle an opportunity, as well as Rob, just to give some thoughts on your best practices, what retailers should be. I mean, you've been dealing with this more so than a lot of retailers for the last 7 months. So what's your advice to the retailers listening?
Well, for me, I find that my sense of time is not what it used to be, and neither is my memory. So it's been really helpful for me, and I think for our team, to keep a timeline of everything that we've done in response to COVID. And it's now owned by our litigation paralegal. And since the early days of the pandemic, it was started by our safety team, and then legal took it over to have as a privileged document. This is our repository for everything we've done by date, as well as where it's documented. It's linked to documents. It's massive, but it's got everything, including the different state and local orders that we were subject to at various times. And so we have one-stop shopping. If we need to go back and say, okay, well, when did we put this particular policy in place? When did we have this order come out in Colorado? What has happened? So we've got a chronology in place. That's been really helpful, at least for us. And then, if I go back to kind of focusing on the employment side, when I was in private practice, I used to say something similar to what Rob said, which is my best free advice to you is just be consistent. And then talk to your teams, and remember that, like your customers, they are bringing their whole selves to work too. People are raw, people are tired. Be there for them, and be there for each other.
Michelle, what thoughts do you have to offer for us?
Yeah, I can agree. I'm a big guru on investigation. So in discovery, I like to have everything in line and prepared. So one thing that we did was we were proactive, and we made sure, like Alexis said, had our timeline prepared, had all of our documents in place, all of our responses to law enforcement, any policy and procedure changes, any messaging that was sent out to associates. I mean, it's a lot of documents and material, but in the event we do get a lawsuit or a complaint or whatever it is, we are prepared, and we have those items ready to go should discovery demands occur. But again, yeah, just having that open communication with associates and being able to navigate these times right now is really hard. So I think Alexis touched on it really, good, that what can we do for you? What can we do to make you comfortable? And just be there for them.
And Rob, from the outside counsel perspective, what are your final thoughts on generally what retailers need to be doing and looking at and thinking about as either they're continuing operations or starting now to increase operations and bring people back?
Yeah, I agree with everything that both Alexis and Michelle said. I think that document. Make sure that you're maintaining consistency. The guidelines that are in place today aren't the same guidelines necessarily that were in place in March or even last week, depending on your jurisdiction. So I think it's very important to continue to monitor the guidelines from state, local, federal government, the CDC, because this is an evolving issue, and the guidance we have today may well be different tomorrow if the positivity rate in the outbreak continues to increase. So I think that you need to be flexible and continue to evolve with your policies and maintain that history. I think the history, as they both said, is crucial. But don't think this is the end of the need to prepare your policies and procedures.
Yeah. I'm going to open it up. We've been looking at the Q&A button throughout the webinar here. So if anyone has any questions, thoughts, concerns they'd like to share, we'd certainly like to hear from you. And I suppose we'll give everyone about 30 seconds to write in to see if anyone has a question for us. Well, apparently you were very comprehensive and answered everyone's questions without anyone actually having to ask you a question. So with that, I want to thank our panelists for taking the time out of your busy schedules to join us. For everyone listening in, I hope you learned something today. If you have any questions, thoughts, concerns, obviously you're always welcome to reach out to either Rob or I directly. If you have questions for Michelle or Alexis, we'd be happy to pass those along as well. So thank you so much, and oh, wait, hold on. Oh, no, just we had an excellent presentation instead of a question. So we appreciate that. Again, thank you so much, and we look forward to catching up with all of you watching online at some point near in the future. Thank you.
Thank you.